Let's unpack this now with Nicola Palmer. She's an associate professor in criminal law at King's College London. Nicola, thank you for joining us on this news hour. Now, the UK says Rwanda has a history of resettling asylum seekers in a skilled way. What exactly do they mean by that?
Well, there has been a long history through which Rwanda has been successful at settling, particularly refugees that have come from the East African region, particularly from Congo. And so Rwanda has implemented very effective policies in relation to both Congo and Burundi. And so really the reference is to their successes in that regard.
Nicola, besides the possible financial gains, what exactly does Rwanda get out of doing this for the UK?
So I think this is very consistent with two policies that Rwanda has been involved in for some time. The first is its push to make itself useful to larger powers that it can then leverage influence. And second, it has for a long time seen the value that Western states are increasingly placing on draconian approaches to carceral border control. And so we've seen this with pushes for individuals around the world to be deported to Rwanda.
Although many human rights groups say that Rwanda has its own problems with freedom of speech and human rights, and yet the UK has still decided to go ahead and do this.
So I think what we are seeing at the moment is, as your report noted, that this agreement has been widely condemned. And the basis for that condemnation is twofold. The first is actually about the legality of outsourcing border control to a third country. And so the legal challenges that we're starting to see here in the UK are focused on the UK rather than on Rwanda. But in addition, there have been concerns about whether or not, or the extent to which Rwanda would be considered a third safe country as far as the current policies of the UK asylum process require.
Well, Nicola, is the UK breaking any of its own laws or any international laws by doing this?
So there is certainly initially legal challenge around this, and we've seen that happen this week. And obviously, the UK government is very strongly suggesting that its position that it is not breaking any international law is correct. But what we are seeing is real concerns about whether this is in line with the European Convention on Human Rights. And we have seen a challenge to offshore processing implemented in Australia that has been brought before the International Criminal Court to push for proceedings there. Now, it's important to note that those proceedings have not gone forward to date.
Can migrants who have now entered the UK and are deemed to be an illegal entry, they need to be sent to Rwanda, but can these migrants actually refuse to do that? What are their rights in this situation?
So the claim is the current legal proceedings are being brought by an asylum seeker who would meet the criteria for deportation to Rwanda. And the basis of those claims are twofold. So the first is the extent to which this would violate the European Convention on Human Rights, and the second is the extent to which Rwanda should be considered a safe country. Now, it is we are going to see the asylum seekers having to be the applicants to take these processes forward, as it looks unlikely that there will be any other route for legal challenge.
Nicola Palmer, thank you so much for your expertise on this. Live to us there from London.